Welcome back to the Law on Partnerships and Private Corporations. Moving on to our next topic, we will now discuss the form of the partnership contract. Does the partnership contract need to be in writing, or can an oral contract of partnership be considered valid? Now, the answer can be found in Article 1771 of our Civil Code. This is the general rule, and the general rule states that a partnership may be constituted in any form, which means that whether the partnership contract is oral or written, it will be considered valid under our law. That's the general rule. However, this rule is subject to several exceptions, which are also mentioned in the Civil Code. First one is in Article 1771, which requires that when an immovable property or real rights are the subject or are the contribution or is a contribution in the partnership, then the partnership contract needs to be in a public instrument. Again, when immovable property or real rights are contributed to the partnership, then the partnership contract needs to be in a public instrument. That's according to Article 1771 of the Civil Code. Next exception can be found in Article 1773 of the Civil Code, which requires that aside from the partnership contract itself, there should also be an inventory of immovable property signed by the parties and attached to the public instrument in case an immovable property is contributed to the partnership. Next exception, as regards the form of partnership contract, we have a situation wherein the capital of 3,000 pesos or more is contributed to the partnership. In that case, or in the case that a capital of 3,000 pesos or more is contributed to the partnership, then the partnership contract needs to be in a public instrument and needs to be recorded with the Securities and Exchange Commission. Again, this is an exception to the general rule, which can be found in Article 1772 of our Civil Code. By way of an example, let us discuss the case of Taurus versus Court of Appeals, a case which was decided in the year 1999 by the Supreme Court. This case involves sisters named Antonia and Emeteria, which entered into a joint venture agreement, into what they call a joint venture agreement with Manuel. Under this so-called joint venture agreement, they were thinking of developing a parcel of land into a subdivision. However, this plan did not materialize, and eventually the land which was supposed to be developed into a subdivision was eventually foreclosed by the bank. Now, apparently this business venture incurred losses, and the court eventually had to determine whether or not a partnership existed between these three persons so that it can properly determine how the losses will be distributed or how the losses will be shouldered by these purported partners. So the court had to determine whether or not a partnership existed so that the parties will know how the losses will be distributed. Now, sisters Antonia and Emeteria argued that the joint venture agreement is void and it cannot be considered as a valid contract of partnership because there was no inventory, considering that there was a real property involved as a contribution to the partnership. They were saying that without this inventory, which was made, signed, and attached to the public instrument, the partnership agreement or the joint venture agreement between them and Manuel is void. Now, the Supreme Court eventually had to decide whether or not the partnership contract or the partnership agreement between the parties was indeed void, as claimed by the sisters, for the alleged lack of inventory. Now, the Supreme Court, in ruling that the contract was still valid, discussed that Article 1773, which requires the inventory, was designed to protect third persons. The Supreme Court said that public instrument, the partnership agreement being in a public instrument, would become useless if there is no inventory, or without the inventory, because without its designation and description, they cannot be subject to inscription in the registry of property, and their contribution cannot prejudice third persons. Now, the Supreme Court noted that the present case between these partners did not involve any alleged prejudice to third persons. Again, the Supreme Court noted that the requirement of an inventory under Article 1773 of the Supreme Court was designed to protect third persons. In this case, which does not involve third persons, the Supreme Court found no reason to apply Article 1773 and eventually ruled that the partnership agreement or the agreement between the parties can be considered valid. Moving forward, let us discuss this case of Suma-chan versus Chua, a case which was decided in 2001 by the Supreme Court. In this case, a certain Lamberto entered into a partnership with Jacinto, who is now deceased, for the business of distributorship and trading of LPG tanks. Now, this partnership between Lamberto and Jacinto prospered, and eventually Jacinto died, leaving behind his wife and his daughter, Lilibeth and Cecilia. Now, Lamberto wanted out of the partnership and asked Lilibeth and Cecilia for his share in the partnership. Lilibeth and Cecilia, in trying to evade the claims of Lamberto, argued that there was no partnership between Jacinto and Lamberto, considering that it was not registered, the partnership agreement was not registered with the Securities and Exchange Commission as required by Article 1772 of the Supreme Court. Again, they were pointing out that there was no partnership for failure to register the partnership agreement with the Securities and Exchange Commission. Now, the Supreme Court, in ruling that there was indeed a partnership between Lamberto and Jacinto, stated that despite the fact that the partnership agreement was not registered with the SEC, the partnership contract remained valid. It mentioned, or it stated expressly, that Article 1772 is not mandatory when it required partnerships with capital of 3,000 pesos or more to register with the Securities and Exchange Commission. Again, the requirement of registration with the SEC, according to this case, according to the Supreme Court, is not mandatory. The Supreme Court further explained that the partnership retains its juridical personality even if it fails to register. Failure to register the contract does not invalidate the same as among the partners, so long as the contract has the essential requisites. The main purpose of the registration, the requirement to register with the SEC, is to give notice to third parties. Well, now that we mentioned that under the law, certain partnerships with capitalization, meeting the capitalization requirement, must register with the SEC. Now here is a checklist of requirements which I got from the Securities and Exchange Commission 2000 Citizens Charter. Note that in having your partnership agreement registered with the SEC, among the documents which you should submit are the following. Among others, you should submit the articles of partnership together with the tax identification number or TIN of the Filipino partners. And there are other requirements which you must comply with if you want to register your partnership with the Securities and Exchange Commission. Article 1764 of the Civil Code states that the partnership begins from the moment of the execution of the contract unless it is otherwise stipulated. So the general rule is the partnership commences its juridical personality, its existence, upon execution of the contract, not from the registration, not from the accomplishment of the inventory, or from any other reckoning period, but the existence of the personality begins from the moment that the contract is executed between the partners.